Okay. Do you want to go ahead and get started, Katya?
Sure, sounds perfect to me.
Okay. Well, we want to first of all, we want to say thank you and welcome to everybody. We're very glad that you're here. I'm Danielys, and I'll be co-presenting this webinar with my colleague and friend Katya. We know estate planning sounds very intimidating, and it's not something that everybody really wants to talk about. But this session is really to provide valuable knowledge. So do not be afraid or discouraged that you may not understand something that we speak about today. We have a Q&A session at the end that if you have a question, you can go ahead and put it in the Q&A box at the bottom, and we'll be very happy to answer any questions you may have. I actually wanted everybody to put where they're watching us from. If you're on Facebook, please put where you're watching us from. And I do apologize that on the actual webinar, I did not enable a chat setting, so you will not be able to put where you're coming from. I'm Danielys. I am the founder of my own law firm called Cardoso Law Firm. I was born and raised in Cuba, and I came to the United States when I was 8 years old. I went to St. Thomas University here in Miami, Florida, where I proudly graduated top of my class. After passing the bar exam, I decided to, hey, why not even make it more difficult for myself and go ahead and open a law firm as well. And I honestly made this decision because I couldn't find a place that really aligned with my values, a place that offered empathy, transparency, and a place that treats clients how I would want my own family members to want to be treated. So that's really why I decided to open up my own law firm so that I could offer that to my community. And estate planning became very personal for me after seeing how many hardworking families, especially immigrants, didn't have a plan. So my mission today is to make this feel less overwhelming and to empower you to take control of your assets and protect your family. And I'm very lucky to be doing this presentation with somebody that I really admire, Katya Kross, who also brings a wealth of knowledge and heart to this topic. And Katya, if you can please tell us a little bit about yourself.
Yes, absolutely. No, thank you. It's a pleasure to be with you here today. Well, my name is Katya. I'm a founder of Kross Law PLC. I work in estate planning, helping people take care of their families through wills, trusts, and all the legal stuff that can so often feel so overwhelming. I also practice immigration law, specifically focusing on the family immigration. As an immigrant myself, I came to the US when I was 10. And like Danielys, I also went to St. Thomas Law School. And that's actually how we met, where we met. I'm also a private pilot and married to an airline pilot too. So when I'm not working, I'm usually in the air or just planning my next trip. We're really into traveling, being an aviation family. I speak Russian in addition to English, and I'm now working on my French too. And I often have the pleasure of working with clients from all different kind of parts of the world. So I'm really glad to be here today, and I'll do my best to make everything easy and simple to understand, as simple as possible. Okay, so I guess we can get started. So first of all, what we'll cover here today. So we can really think of today as of a kind of legal overview of estate planning. And of course, it's not just one, but rather two estate planning attorneys. So you'll get to learn about the differences between the will and a trust and reasons why one might be better for you than the other. You'll also hear us talk about how to legally avoid probate and save your loved ones that very essential time, money, and stress, how to make sure your kids and assets are protected. And yes, there will absolutely be a Q&A, a live Q&A at the end, so make sure to stick around. And we will also be offering a bonus gift at the end of this session. So yeah. So how would you know if you are in the right place? Because let's be honest, like we already said, estate planning oftentimes feels quite overwhelming to many people. If you've been putting it off, wondering if maybe you can just do it yourself by just doing something simple online, just enough to cover your needs, Believe me, you're not alone. This is pretty common for people to think like that. Or maybe you were just wondering if what exactly you can do to help your family avoid court fights and additional stress and expenses. And we will be covering all of that here today. You're absolutely in the right place.
So let's do a little warm up. Let me share the first poll. And basically, we want to know, when you hear the term estate planning, what is your first reaction? You know you need it, but you haven't started. You already have something in place. Does it sound overwhelming, or have you really not thought about it? And I'm gonna give it just a few seconds. And it looks like the majority is between sounds overwhelming or haven't really thought about it, which is pretty normal.
Yeah, that's a pretty common response. But this is what we're here for, right? Today, to talk a little bit more about it, talk about why it's important and what things to consider. So, yeah. Well, let's dive right into it. Do you already have an estate plan? So here's a catch. You might think that you don't have an estate plan yet, but you actually do. It's just the estate plan that the government has written for you. It is the default that everyone gets, but trust us, it doesn't necessarily go as everyone actually wants. Estate planning, your choice to do estate planning is really your chance to opt out of the default plan and create one that truly reflects your wishes and your real preferences. So, moving on, what happens if you don't do anything? Before we actually jump into what the options are, let's first talk what will happen if you just decide that, you don't want to do anything. What happens basically if you don't opt out of that default plan? Well, first of all, certainly there will be probate. Everything you own will have to go through the probate court, or basically everything you own will have to. And we will talk about the positives and negatives of that because there are some of those. And the court would decide who gets your assets and who raises your children. Your loved ones will go through this very long, very much public, and very expensive probate process. So let's talk a little bit more what exactly would happen to your children. Because one of the biggest heartbreaks that we see is families who didn't plan for guardianship. If something happens to you, it will be the judge and not you who chooses who raises your kids. And it might be a family member that you wouldn't have necessarily chosen yourself, or it might not be a family member at all. And overall, the guardianship process can be quite long and expensive and complicated. And again, of course, stressful because all of this, you have to go to court. It certainly brings stress. So going a little bit more in depth, how does the guardianship process exactly look in the Sunshine State in Florida? So our guardianship requires court filings, legal fees, and oftentimes months of waiting. Remember, the guardianship fees, like the compensation for the attorney and the guardian himself or herself, of course, because they are entitled to compensation, all of that would come out of your child's inheritance, effectively draining the money and the assets that the child would have otherwise inherited. And yes, without proper planning, children can be placed in foster care and shelters, being put in unfamiliar environments with unfamiliar people during those already quite stressful situations. If you'd like an out-of-state relative to be a guardian, then that would typically make the process even harder and longer with some potentially additional delays. But there is a good news, and that's basically that there is a way to prevent many of these issues. First of all, you can name guardians in your estate plan for both death and incapacity. And you can even include backup choices. So if in case your first choice guardian is unable to serve, you would have someone else written in your plan who would be able to step in and take care of your children. There is something called pre-need guardianship declaration, and it creates a presumption that your chosen guardians will be appointed, simplifying the whole process and preventing, potential family disputes that oftentimes arise in these kind of situations. After all, when your wishes are clear, it truly gives your family guidance and protection at the time that they need it the most. Of course, during those stressful times when, God forbid, something happens. So, talking about guardianship and all of that in general, let's also touch a little bit on guardians outside of Florida and outside of the United States. That's actually a question that we get quite often. Um, and the answer is yes, your chosen guardian can live anywhere in the world. But there is a catch. Florida courts generally prioritize in-state residents to be guardians. And if you prefer a guardian who is out of state, they must be a relative. And even then, the approval process takes longer. To speed things up, we help families file something called a pre-need guardian declaration, which is what we already talked about. You can file it in advance. This one document can make all the difference during already hard times and reduce delays from weeks to as little as days. So just to kind of make it a little bit clear, how exactly this would work in a certain situation, let's talk through a case study, like an example case study. Meet Lily and Bill. They live in Fort Lauderdale with their 6-year-old son named Danny. They haven't formalized a guardianship plan, but they have talked about it before. One weekend, they're driving to the beach and they get into a serious car accident. Both parents are unconscious. Danny was in the back seat, so he's luckily unharmed, but he is left without anyone who would be legally authorized to take care of him. And this is truly when the lack of legal guardianship plan becomes very real and very concerning. So what exactly would happen next? First of all, police would find that there are no nearby relatives, and they would call the Department of Children and Families, or DCF. Even though Danny explains that his parents oftentimes leave him with Rachel, who is their neighbor and close friend, the police can't release him to Rachel because there is no legal documentation that would allow Rachel the power to take care of Danny. Danny ends up in maybe a shelter or maybe even foster care, while his family and friends try to get some kind of legal authority to hopefully bring him home. It's heartbreaking and it's very much avoidable. So let's discuss someone else. In addition to Rachel, who is the neighbor of Lily and knows Danny quite well, Danny also has an aunt, Sandra, who lives in New York. And of course, when Sandra hears about what happened, she right away offers to fly down immediately to take care of Danny. But again, she doesn't have any kind of immediate legal authority. Florida law requires home study and court approval before an out-of-state relative can take custody. This generally can take weeks or even longer, even in some expedited cases. So while Danny's scared and alone, surrounded by strangers, the people who love him have to jump through a lot of legal hoops and barriers to step in and help out. So this is how it could have gone, if you don't have anything in place. And unfortunately, that's how sometimes these situations turn out. But let's talk about what could have happened instead if the Danny's parents actually did some guardianship planning. If Lily and Bill had created a pre-need guardian declaration, Danny could have been placed with Rachel, their neighbor and friend, right, almost immediately. Sandra, Danny's aunt from New York, could have taken Danny much faster, potentially even twice as fast as without any kind of proper paperwork. So these are really just not just legal documents. They're tools to give your children, your family, basically the stability, the safety, and the familiarity when they need it the most. So this is generally how a guardianship goes, and this is why it's very important to plan ahead for it. Now, Danielys, can you share with us what steps can a person take to protect his property and assets moving on from guardianship?
Yes, my pleasure. But before we do that, let's do a poll first. Let's
Perfect.
do, we wanted to know if something happened to you today, whether you have any legal documents in place naming guardians for your kids. So I'm going to give it a few seconds. It looks like it's 50-50 between yes, somebody already has a named guardian, and no, but I've thought about it. And poll, your results. It looks like everybody here has kids because no one put, I don't have children. Okay. So moving on. So when we say estate, we're not just talking about a fancy house or a big mansion. An estate really encompasses everything that you own, like your home, your car, your bank account, a retirement plan, even your furniture, which is something that most people don't think about. If it has value, it's part of your estate. And if you don't have a plan, the court really decides how that is going to get divided up, which in reality, it may not match what you would have wished. And this is just a slide pointing that out, that most people don't think of their bank account, a car, a business, all of that encompasses an estate, really. So when it comes to estate planning, most people think of a will. That's the first thing that they think about. But in reality, there are two main tools that you have to pick from. You have the option of a basic will, and you also have a revocable living trust, which sounds very fancy, but it's really, it can be fairly simple. Both can work, but the impact that they have on your family, your money, and the legal process are very different between the two. So in a moment, I'm going to walk you through the differences and how one may not be the right one for you or your family. So we have the last will and testament. It's the one that most people are familiar with, and it does allow you to name your who gets your assets, who handle things, and who takes care of your kids. So it does take care of that. But here's what most people don't know about a will is that it goes through probate court. It's public, time-consuming, and it can cost thousands of dollars in legal fees. So yes, I mean, in reality, it's better than having nothing, but it doesn't avoid court, which is something that most people believe a will does, but in reality, it doesn't. So here's the part that surprises most people. How much can probate cost? Because some people are, okay, well, my family has to go to court. So what? Well, here's the surprise. It's a process that can take months, even years, and it eats up 4 to 7% of everything you leave behind. This means that if you have an estate that's worth, let's say, $300,000, your family could lose from $12,000 to $20,000 just in probate cost. And it's all public, so anyone can look up your will. So let's take, for example, let's do a case study like Katya did previously. We have Jenny. She has a home, she has savings, she has life insurance, and a few valuables. And if you add up of Jenny's assets together, she has about 3.1 million worth of an estate. If her assets had to go to probate, her family could lose around $32,000 just in court and legal fees. And that's based where today we're specifically focusing on the state of Florida. If you're watching us from a different state, this number could vary, but specifically for the state of Florida, it ranges from 4 to 7%. And this is why you can imagine that most families look forward to avoiding probate altogether, because a lot of money gets lost. And here we have a chart of what Florida considers a reasonable probate fee. So this number can grow pretty fast depending on how large your estate can be. So for example, if you owe $1 million estate, your loved ones could lose all the way to $60,000 in probate, which is a huge number. So let's do, this is a good point to stop for a poll. Let's do this poll. Were you aware whether the probate process can take from 6 to 18 months and cost your family 4 to 7% of your estate? It looks again like it's 50-50. Let me share. Let's give it a minute. Okay. So it looks like it was 50-50. Some people are saying, yes, I heard it's expensive, but I didn't know the details. And some people are saying, yes, I knew about this, which is probably why you're here in this webinar in the first place. Okay. So moving on, this points out whether that even though a will can be very helpful because you're not just depending on the Florida statutes, it's far from perfect. It doesn't keep your family out of court. Probate is a public process which can drag on for even up to a year, and everything becomes public record. So that means your family is not going to have any privacy. If you have any family drama, everybody's going to be able to witness that. A will does nothing for you while you're alive. So if you're in an accident or become incapacitated, your loved ones will have to just go to court. And lastly, your assets will go right to your kids as soon as they turn 18. There are no restrictions, no protections, and this can be very risky for reasons we're going to point out throughout the webinar. And that's because in cases of divorce, creditors, or just inexperience, or God forbid, alcohol or drug addictions that your kids may develop throughout their life, it can be very risky for them to just get their full estate right on after they turn 18. Now, something that everybody asks is, after all of this, why would anyone want to do a will after explaining all this process? That's because if your estate is very small, meaning in the state of Florida, if it's under $75,000, and that probably means you don't own a house, because we know that in the beautiful state of Florida, there is no property that is worth less than $75,000. Probate, in that case, may not be as complex. It may be fairly simple, and that's a reason to just do a basic will. Or if you expect family drama, if you expect your family to unfortunately be greedy or have disputes, and they're going to end up in court anyways, then having a will might be the good solution, because in that case you would want a judge supervising the whole process. So now let's talk about the second option, which is trust-based planning. A revocable living trust does everything that a will does, so everything that I just spoke about, but it goes a step further. It helps you control the trust while you're alive. It avoids probate. So most people that opt in for the trust-based planning, it's because they don't want their family members to end up going to probate, to court. And it protects your family while you're alive and after you're gone. With a will, you can't really, it doesn't plan for while you're alive. It only plans for after you're dead. It is one of the most powerful tools available for families who want peace of mind and privacy. And we wanted to put in this slide because this is probably one of the biggest misconceptions we see is that people think that trusts are for millionaires, for people with yachts, for people who win the lottery, who have vacation homes. And this is not true. Trusts are for regular families, regular middle class families who just want to stay out of court, keep things private, and make life easier for their kids or their spouse. If you own a home, have minor kids, or simply want to stay in control, a trust is one of the smartest tools you can opt in for. So what is a trust really? Because it sounds like something alien, something foreign. A trust is a simple legal document that holds your assets and says exactly how you want your assets to pass to your family, both while you're alive and after you pass. It's private, it avoids court, and it can be customized to your family's needs. That's probably the most important asset about it, is that it's customizable, much more than a will. And fairly quickly, just to explain the three roles that encompass a trust, you are the grantor. So the moment that you decide to create a trust, you can do it, if you're married, you can do it jointly with your spouse, or you can do one as an individual. But the person or the two people who create the trust are the grantors. You're the one that basically sets all the rules when you create it. And then there's also the trustee, which is the person who manages it. This can usually be you. Most people opt to be for themselves to be the trustee while they're alive, and then they name somebody else once they pass away. And this is basically the person that manages the trust. And then lastly, the other role is the beneficiaries. These are the people who you want to leave your assets to, like your kids or your spouse. And if anybody has any questions, please feel free to put them in the Q&A. I know we're going fairly quickly. It's just that we have a lot of content to get through. And one of the biggest fears that we hear is, I don't want to lose control of my assets. I don't want to put something in a trust and then not be able to take it out. With a revocable living trust, you have full control over your assets. Sometimes people confuse a irrevocable living trust with a revocable trust. And the revocable one, the one that's revocable, not irrevocable, you have full control over it. And for the purposes of this webinar, we are not discussing irrevocable living trust. FYI, they're very complicated, and that they can take a whole webinar themselves. So think of a trust with we wanted to compare it to something that you can put into perspective. Think of a trust like a kid's backpack. They all look different, but they all serve the same purpose, which is to carry and protect what's inside of it. And some families need something simple. Others need something with more features, more colors. It's really, you're the one that gets to decide how your trust looks. So once you set up the trust, and more importantly, once you retitle all your assets into the trust, here's what happens. Your family gets to skip that 4 to 7% in lost in probate because there's no longer any court involved. And your loved ones will get their inheritance within weeks, not months or years. Everything stays absolutely private. It's not public record. As a matter of fact, you don't have to tell anybody that you have a trust. So you don't, even if you, whoever you leave as a beneficiary, doesn't have to find out that you named them as their beneficiary until you pass away. So you don't have to tell anybody anything regarding what's inside your trust. It can stay completely private between you and your attorney and your spouse if you have a spouse. So one of the biggest fears that we hear from parents is, what if my kids aren't ready? What if I leave them with a bunch of money, a bunch of things, and somebody takes advantage of them? Well, this is what's magical about a trust. With a will, you can't really control that, right? I mentioned earlier that with the will, once your kids turn 18, they're going to get their inheritance like completely. No rules, no timelines. If you have $1 million estate, your kid is going to earn $1 million in their bank when they turn 18. With a trust, you can set rules and timelines for inheritance. So they're protected not only from themselves, because let's be honest, do you want your 18-year-old to get $1 million when you turn 18 and they're really going to take advantage of it? Probably not. With the trust, you can set guidelines. You can set 18, I want them to get just enough to pay for college. At 25, just enough to open for a business. At 30, that's when I want them to get everything. So you have complete control over how your kids inherit their estate. So this is another good point to do the third poll. So at this point in time that we have mentioned wills versus trust, what do you think will work best for your family with the information that we have provided? So I'm going to give it a few seconds. Okay. It looks like it's 100% I need a trust.
Yeah, and that's what we hear quite often, right? Most people prefer trusts because, well, they're based on all the benefits that we just discussed.
Yeah.
So,
So now that we have discussed the difference between a will and a trust, Katya's going to take it away with explaining something very important, and also something that we don't really think about is what happens if I'm still alive, but I'm incapacitated and I can't control my assets. What happens then in that scenario?
yeah, exactly. And I know we touched already on the guardianship for minor children, but it's also important to think about the guardianship for adults because, a big benefit of a trust is that it can help avoid guardianship for an adult or an elderly person if there is ever incapacity or disability. And generally speaking, guardianship is one of those things that everyone, meaning adults, of course, want to avoid. It just takes away your legal right, your ability to make decisions for yourself, choose where you want to live, choose how you want to use your property. So generally speaking, everyone wants to avoid guardianship. Um, and as briefly mentioned, also, guardianships tend to be very expensive. They are expensive. By having a trust, the court is much less likely to even start guardianship proceeding in the first place. And especially if, in addition to the trust, you also have proper other forms like the healthcare directives and the power of attorney, the durable power of attorney. And unlike normal guardianship, a trust does not require a lengthy court process before a trustee can actually step in and start taking care of your property and managing your assets. Like, for example, taking care of property maintenance, paying the required bills, taking care of insurance, things like that. The trustee can just step in without the court involvement. And in your trust, which is, I think, a huge benefit, you can also specify how exactly you would like to define incapacity. You make up the definition of incapacity. You can choose how many doctor opinions you want. You can choose maybe you just want opinions of your loved ones or loved ones and the doctor. Basically, you decide. It can be something called incapacity panel, and those people would be not choosing, but making the decision whether you're incapacitated for the trust purposes or not. So you truly are in control of your trust, right? That's the huge benefit of it. You really make it the way you want it. That's the common theme. You get to choose exactly the terms and the characteristics in your trust that you want. So also to kind of better understand how trusts work, let's talk through a little case study. Uh, so let's meet Michelle and Thomas and their two kids, Isabella and Jake. Isabella and Jake grow up, and once their parents pass away, they get the inheritance by intestate succession, meaning without a will or a trust. Isabella marries Luca and commingles the inherited funds in their joint account, putting them in their common bank account, just for simplicity and convenience, and paying general household expenses, things like that. Unfortunately, Isabella and Luca's marriage doesn't work out and it ends in divorce. But now Luca can get as much as half of Isabella's inheritance. Now, if Isabella had a trust, this wouldn't have happened. But since it was given to Isabella outright without a will, or I mean, even with a will, it would still be outright, most likely. This is the situation that it led to. Okay, let's talk about Jake, the other child of the couple. Well, now an adult, right? Jake is not married and did not commingle his funds with anyone. But Jake is an adventurer. He regularly goes hiking until sadly he slips and gets injured in a hiking accident. In addition to injuring himself, Jake accidentally injured another hiker as well. A lawsuit followed, and because Jake's inheritance was in his personal bank account rather than a trust, it wasn't protected. So a lawsuit really just wiped out Jake's entire inheritance. And, we typically don't think much about these kind of situations, but they are definitely very important to consider and especially important to keep in mind when you're making your estate planning decisions and creating your estate plan. So here's one more analogy that I love. A children's trust is really like a tube of toothpaste. You can squeeze out what you need, but the rest stays inside and it stays protected. That means that your child or grandchild can access funds for what matters, like education, housing, emergencies, things like that, while keeping the rest shielded from lawsuits, bankruptcy, and bad decisions, creditors, basically situations like that. It's one of the most loving gifts that anyone can leave behind. So this is something called a common trust, children's trust, common trust, and it is generally the most useful for kids, and it imitates the way most families really manage their money day to day in normal day-to-day life. For example, if you as a parent need to pay $3,000 for braces for one of your kids, you will not right away feel the need to give the other kid $3,000 too, right? Because that's just the way it goes. One kid needs braces, so you're gonna pay the braces for that kid, but doesn't necessarily mean you're gonna give $3,000 to the other kid. Or let's say your daughter needs $200 on a dance costume for her dance competition, but then you won't automatically give your son $200 too, right? Because we're just living day-to-day life with day-to-day expenses. As a parent, that's just the way you typically go about it. But this is exactly something that a common trust can do as well, basically imitate that normal everyday life expenses. It would cover kids' general expenses until a specific age. Then you would have the option of simply distributing what is left in the trust outright equally between the kids when they're old enough. So that's a very nice estate planning technique and tool that a lot of people appreciate. Now, let's talk about the elephant in the room, because of course, everyone wants to hear about the estate taxes and understand if they should be worried about them. Here's the good news. There is no estate tax in Florida. We're both
Yes,
Florida attorneys.
yes.
Yay, right? Good news. So we can really mostly speak to Florida. But there is also some bad news. There is a federal estate tax. Right now, though, it only applies if your estate exceeds 13.99 million. So I think it's pretty safe to say that most people don't really need to worry about it, meaning if your estate is not more than 13.99 million, you don't have to pay a tax. So that's good. And it sounds like a lot, but this exemption is scheduled to decrease in 2026, probably to around 7 million. Still, even for 7 million, I think it's pretty safe to say that most people don't have estates that are over 7 million. So probably still nothing to worry about. But it's still important to keep in mind that this number fluctuates quite a bit. And actually, as recently as 2008, it was just 2 million. And in early 2000s, it was actually less than a million. So if you're anywhere near that threshold, or you plan to be, or want to be, or maybe in some time in the future, this is certainly something to watch out for and potentially think about working around, if needed, definitely if needed. Okay, so let's also touch on some different estate planning documents in addition to the will and the trust. Estate planning is certainly not a one-size-fits-all kind of solution. That's why we like to explain it more like a menu. You can pick and choose, or you can just go for a full protection set. Each document plays a very specific role, and when combined, they work together to truly give you the peace of mind and real security. So first of all, we have the durable power of attorney. It's truly all about control during your lifetime. If you become incapacitated, even temporarily, this document gives someone you trust the legal authority to manage your finances, pay your bills, handle your contracts, real estate transactions, things like that. Without this document, your loved ones may have to go to court to get that essential authority. And that process can be expensive and slow and stressful because, like we already talked about, generally, when you go to court, things tend to take time and it can get certainly expensive and stressful. Meanwhile, while you're in court, no one is there to take care of your property and pay the bills, and your loved ones might not even be able to access your bank accounts. Now, we also have two healthcare directives, basically the living will and the surrogate designation, healthcare surrogate designation. The living will allows you to make your own medical choices in advance. For example, if you don't want to be kept on life support, if you are ever in a permanent vegetative state with no chance of recovery, you can specify that in your living will. You can basically make those medical decisions for yourself in advance. You can also choose someone who would make the medical decisions for you in case you are unable to, like let's say you're unconscious or God forbid you're in a coma, something like that. This is something called healthcare surrogate designation. It names someone to make those decisions for you, basically, if you are unable to communicate them. Together, these two documents help avoid family disagreements and court involvements during medical crisis. And again, they're there to really give your family the peace of mind and allow your family members to know your wishes in advance. Now, we also have two more documents that every family should consider. That's, of course, the HIPAA authorization. That's something that's certainly often overlooked, but it is so, so important. HIPAA laws are there to protect your medical privacy, and that's certainly a good thing. But it also means that doctors can't speak to your spouse or your adult children or anyone else unless you have given them the permission to. And this form ensures that in an emergency, your loved ones can get the information that they need so they can get updates on your condition if something happens. Um, and maybe, this would allow them to even provide some essential information about perhaps some of your medical history or your allergies, something like that, that otherwise the medical team might not be able to know. Also, we've already touched on the pre-need guardianship declaration. It's certainly very important for parents of minor children. It's also important for anyone who is planning for their own incapacity one day. And this document really just allows you to name who you want and who you don't want to serve as legal guardian. Um, Without it, it would be the judge deciding who would be the legal guardian. And it's also helpful if your preferred guardian lives out of state or even outside the country, because it truly speeds up the approval process and gives weight to your wishes. Basically, then the court knows exactly what you wanted, who you wanted to be the guardian. And yeah, so moving on, I think now Danielys will talk more about it, about how everything, all of this truly comes together.
Yeah, and just to add, any estate plan really created by Katya or myself will have all of these a la carte documents. So there's attorneys that really just do the trust or the will for you, and that's it. When either of us do the estate plan for you, we include all of these documents: the pre-need, the HIPAA, the healthcare proxy, the living will, because all of them really are important. There's really no point for you to have a trust, but if you become incapacitated, then what does your family do in that case? So for all of estate plans created by Katya and myself, we include all of the a la carte documents.
Absolutely. That's the way you get all the protection, right?
Yeah.
Because without something, without one of these documents, you just won't have the everything you would need.
Yeah. So we wanted, going back to what I said at the beginning of the webinar, of the reason why I opened up my own law firm was because I couldn't find one that really went hand in hand with my own personal values. And just some tips on when to choose an attorney. Ask. Sometimes I find that people are hesitant to ask about pricing. Ask straight up if they offer flat fees, because you want no surprises. Whether they will help you update your plan. Is this an attorney that's just going to do it the first time? And then what if something happens? Especially for younger families in their 20s and their 30s, as time passes and your kids grow, your estate plan is going to change. We guarantee it. If you're doing your estate plan in your 20s, by the time you get to your 50s and your 60s, you're going to have to update it. Because unfortunately, life happens and some family members may have passed away, some become incapacitated. Maybe you got into family drama with a cousin that you no longer want to leave anything to. So watch out for that. Watch out for a law firm that not just offers a plan on a one-time basis. We actually offer a yearly meeting update with our clients. So once a year, for all of our estate planning clients, we have a meeting with them and ask them if there's anything that they want to update in their plan. And most importantly, do you feel comfortable with your attorney? And this is a matter of this is why, for example, we require a personal consultation, because out of this webinar, it's a webinar offered to the public. But when you come into our office or when we have a private meeting with you, that's when you're really going to start seeing more of our personalities. Do our vibes match, basically? And do you feel respected? Do you feel heard? Which again, when I work for other, and I'm not saying in specific names because I don't want to get sued, but I'm just saying, when I used to work at other law firms, some of them wanted me to do my consultations in 15 minutes. And I would object. In 15 minutes, I cannot possibly get all the information to best serve my clients. Like, this is not, the legal profession is not a factory. We are an extension of our clients. We are their voice. So there's no way that in 15 minutes I'm going to know how to best serve my client. And that's something that you have to watch out for. And anything to add, Katya, on that?
No, I absolutely agree. I think it's very important that you have the connection with your attorney and you truly feel comfortable, it has to feel like the right person. And sometimes you're going to hear about oh, you can get a trust very quickly done online, or oh yeah, I do 5 trusts a day, something like that. That's probably a cookie cutter trust that you might not want, because kind of how Danielys was saying, a trust is really your backpack, right? The backpack that you kind of get to create yourself. So if someone is making 5 trusts a day, then it most likely it's just not a very personalized solution, and maybe wouldn't exactly address all your needs and concerns and things like that. So we try to really approach it in a very personalized way and really ensure that everything that our clients need, everything that our clients have as concern is addressed.
So before we move on to this, I just want to check the Q&A real quick because I know we don't have a chat, unfortunately. Q&A. It looks like we don't have any unanswered questions. Okay. So before closing up today, as a way to give back to our community, we are actually offering free estate planning consultations until July 31st. You will get again, because we don't have a chat, unfortunately, I am unable to share the link to the calendar where you can schedule your consultation. But within a few minutes after the webinar ending, you will receive a follow-up email with the link where you can schedule your free personalized consultation, where we're going to take in detail, we're going to look in detail into your assets, your family situation, if you have kids, your wishes, how you want your plan to be formalized. And then depending on what we discussed in the consultation, then we're going to give you the pros and cons of wills and trusts. And ultimately, though, you as a client, again, decide, because we are, as attorneys, we are not here, and this is certainly my style and Katya's style, we are not here to push any decisions onto you to make more money. And I know something that's something that's really going out in social media, that attorneys are out to get you and attorneys don't care about you and attorneys are expensive. That's not really how I work, and that's not really how Katya works. We are here to present you the pros and cons. We are an extension of you, and we want to build you a plan that works best for you and your family. So that's why we don't really mention our fees in webinars, not because we're trying to hide any like the fees. It's because the attorney answer is it depends. It depends on your estate. It depends on what you want. So that's really, we can't really present this is how much it's going to cost, because it really depends on you and what you want. So that's why we welcome you and encourage you to schedule your free consultation until July 31st. And in the consultation itself, we're more than happy to review the fees. Okay. Anything to add before we end, Katya?
No, not really. I can share my screen for the link, but I
Yes.
think we also need to touch on the the um I think we have one quick question.
Okay.
Someone's asking, how often should I update my estate plan?
I would say as often as something life-changing happens. So if your main beneficiary passes away, you definitely need to update your estate plan. If you get into a family brawl and you want to disinherit somebody specifically, update your estate plan, because they will, if you pass away tomorrow, they're going to get your assets. If you get divorced, that's a life-changing decision. If your spouse passes away, that's a life-changing decision. So the answer is really it's up to you. It's up to you, but if something very important occurs, act quickly. So
Absolutely. Absolutely. Yeah, I completely agree. Lots of things can happen. So important to go back and recheck it regularly. And here's the link. If you can, if you just want to type it in, or as Daniela said, we will also make sure to send out emails with the link as well. Um, yeah. Well, it was very nice to have everyone here today. And it was a pleasure to share this information with you, and we hope it was helpful and useful, right? Anything?
we hope it was helpful, that it was valuable. And just to mention that we're going to keep providing these webinars on a monthly basis from now on. So feel free to follow us on Instagram, Facebook, to subscribe to our emails, because we will keep offering these knowledge, these valuable webinars on a monthly basis from now on. And if
Absolutely.
anybody has any questions regarding anything that we mentioned, please feel free to reach out to Katya and myself.
Perfect. Perfect. Absolutely. Well, thank you, everyone.
Thank you, everybody. Have a good day.